The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone, and welcome to today's webinar under the Startup Development Program webinar series. And today's topic is on founder and employment agreements, stock options, non-disclosure agreements, as well as non-compete agreements. So thank you once again to our audience for joining us today, and we hope that you have a fun time. So this is the last webinar in this series. However, we do have more upcoming webinars in 2018. You'll be receiving announcements about the webinar offerings for next year in upcoming emails and announcements. So please watch out for that. As always, we will have Q&A at the end. So just go to your questions box of your GoToWebinar control panel and type in your questions. We'll try to get to as many questions as we can by the end of the session. Also, as you know, the slides and video recording will be made available 24 to 48 hours after the webinar concludes. You will receive an email from us as soon as the slides and video are available. However, you can go to nset2.org/YouTube if you want to watch previous webinars in this series, or go to nset2.org/webinars to view other webinars that we've done previously, as well as archives of webinars in this webinar series. As you know, we'd like to engage you, especially if you're a university or if you're an entrepreneur, to number one, submit your IP or your startups to NSET2. We do have a startup development program, and we are accepting IP and startups from universities to see if you are a good candidate for the program to develop a startup around. So right now we are accepting applications for IP and startups. Just go to nset2.org for more information. If you're an ex-corporate, from open innovation, from venture capital, a serial entrepreneur, as well as an active angel investor, we are still looking for startup development officers to help develop IP into startups under the Startup Development Program. So if you're interested in knowing more about being an SDO, just email us at startupdevelopment@nset2.org. Send us a copy of your CV as well as a short note, and we'll reach out to you and schedule a phone call to see if you're a right fit for the program and if this program is a right fit for you. All right, moving on. So today's webinar, again, is on agreements. So as you know, last week we did a session on how to build a team and how to find members of your board of advisors or board members. So we're taking care now of the legal part of dealing with team members as well as advisors, or those people that you work with when you start or when you work on your startup. So our speakers today we'll talk about, number one, the Startup Development Program, and our second speaker will talk about the agreements when dealing with your team members. So our first speaker is Dr. Glenn Vonk. He's our Director of Business Development and Alliances at NSET2. He was a former Director of Advanced Technology at BD Tech. And also speaking today is Andrew Tucker. He's an NSET2 Startup Development Officer as well as a partner in Womble Bond Dickinson. So Glenn, take it away.
Okay, thank you, Ria. So it's my privilege to provide you some background on both NSET2 and the Startup Development Program. Next slide, please. So I'll let you read through this timeline, but basically over about almost the last 3 years or so, NSET2 has been on a journey to understand how university research is commercialized into the marketplace. We began by seeking out corporate partners to have this discussion with Congress, which was asking us about how to improve the return that they see from their investment in university research. That developed into, I think, a deep understanding of universities and startups' interactions with corporates. And our first program coming out of that was the Demo Day in late 2016. The Demo Day is a very efficient way to connect startups to corporates, and we've had great success with that on 2 occasions, and we're planning again to do another one in the next year. And at the earlier stage, a new program is the IP to Startup program, a program to look earlier for interesting intellectual property that has the potential to be very valuable as a startup, either to a corporate or as a stand-up company. And then the startup development program is to provide additional resources to startups as they navigate their way towards commercialization. So this is very exciting for us now to see all this coming into reality. Next slide, please. So the model that emerged from our discussions with different members of the ecosystem is shown here. And you can see the research investment at the upper left that's packaged into startups at the upper right. And then the connection between the different members of the ecosystem happens with the Corporate Commercialization Council, especially with our corporate partners. And that seems to be, often in the ecosystem, the most difficult part of this, is to find the alignment with corporates and for those that are wanting to create successful startups to know what the corporates are really going to engage with. Beyond that, it's necessary to secure early stage funding to move them to a place where the risk is sufficiently low that a private investment is actionable, and then of course that leads to a commercialization event. So that's the model that emerged. It was tested on the East and West Coast at multiple locations with all the members of this ecosystem. Next slide, please. So Congress, again, makes a big investment in research, $137 billion if you include the federal labs and the universities. We think that this is an excellent resource for researchers, of course, seeking new knowledge, but also for that knowledge to create exciting new business opportunities for those startups, those investigators, and also corporate partners. Right now, we have Fortune 500 members and startup development officers who are reviewing oftentimes those that research in those startups, and they're very interested in partnering and working with them to commercialize those opportunities from that $137 billion investment. Next slide, please. So the startup development officers work with the university entrepreneurs, faculty, researchers, and students to create, develop, and fund market-aligned university startups. And by market alignment, we mean that those opportunities are vetted by the universities, by the entrepreneurs that are in our network, and by our corporate partners. And when all of that is aligned, then we get excited about creating that startup. Next slide, please. So the services that the startup development officer can provide, again, are to assist early management teams in developing business plans, proof of concepts, prototyping, early product development, and public and private funding for their startup. We often talk about commercialization experiments, and these are ways to explore concepts and to obtain an early read on whether those concepts are commercializable and what the size of the opportunity might be. So, and that's often, again, from different members of the investment and corporate community working alongside of the university entrepreneurs. Next slide, please. Benefits are access to professional talent to accelerate development of the startup. And then for the universities, intellectual property can move to significant market events. Of course, licensing and sponsored research is part of that. We particularly like to think about startups as being a very efficient way to commercialize university research. Second benefit is the graduating students into startups and working alongside of those Fortune 500 companies and startup development officers is a great opportunity for them to grow. And since management talent is limited everywhere, this is a great pool for both the startups as they are developing and for the future. Next slide, please. So to engage with us, you can either submit your startup or your IP to nset2.org, If you want to be a startup development officer, apply to the email address shown here, and we'll repeat this at the end of the presentation for you. Next slide, please. So it's my privilege to introduce Andy Tucker. And Andy has more than 30 years of experience as a trusted corporate and securities advisor to growing companies, particularly in government contracting and technology sectors. His clients operate around the globe. He regularly advises companies throughout North America, Latin America, Europe, Middle East, China, and Australia in corporate matters involving cybersecurity, government services, contracting, telecom, managed services, renewable energy, medical devices, energy, pharmaceuticals, aviation, consumer product, and financial technology companies. It's a broad menu of expertise. Andy is an active member of the community to assist in its growth. He currently serves as a member of the Board of Directors of the Maryland Technology Council, the Membership Committee of the Small and Emerging Contractor Advisory Forum, the Board of Advisors of the DC Archangels, and the Executive Committee of the MIT Enterprise Forum of Washington, DC and Baltimore. Andy's run 18 half marathons and taken 4 companies from startup to IPO. Andy, it's a pleasure to introduce you today.
Thanks. It's a pleasure to be here and addressing the fairly extensive crowd we have on the right before a holiday. You know, I've done this presentation a few times in the past, and as we were talking with Glenn beforehand, I think we're going to go a little bit slow at the beginning on the slides, talking about founder agreements. We'll kind of speed up a little bit during employment agreements, and then slow down again as we get towards the stock option plans, because my experience has been that's where people are more interested in, and so I'll try to address and anticipate the questions in advance. We can go to the next slide, Ria. Okay, this is what we're going to try to cover in our 40 or so minutes. We're going to generally talk about founder agreements, employment agreements, and then there are obviously some headings under employment agreements. And like I said, I think most of you are founders, so you're probably more interested in the founders agreements and then the stock option plans at the end for incenting your future employees. Next slide, Ria. And again, next slide. There are kind of 3 main kinds of founders agreements. The first one we should talk about is actually at the bottom of the page, is kind of the assignment of the intellectual property. You know, each of these startups will obviously be based on intellectual property, you know, stuff that you've invented or developed in your labs, and you know that intellectual property has to get into the company, and it's that contribution of the intellectual property that will give you your shares of stock in your corporation, and the relative value of various pieces of intellectual property that may be coming in at the beginning, you know, will determine, you know, how much it's worth, and in percentages. And at this early stage, when I say how much it's worth, I'm not saying you're going to get a valuation and then divide it up. You're going to kind of sit around a coffee table and negotiate it out amongst the various founders. Obviously, this gets complicated by, you know, licensing agreements with the university or contributions from the universities in terms of how they, you know, view the ownership of the intellectual property and how they want to transfer it to the startup. But I think that's a topic for a whole nother webinar. The next one is kind of the top, is kind of the buy-sell agreement. Basically, if one buyer partner desires to sell or is not hitting a benchmark, the other partner has the right to buy that person's shares or force the sale of the shares. So, you know, the idea is, you know, if you know, 2 people found the company and one person is devoting his life to the company and the other is devoting his life to windsurfing, doesn't seem right for the windsurfer to keep his shares in the company. And a buy-sell agreement is a way to kind of force that person to sell his shares. You know, it will force somewhat painful discussions, or could, amongst colleagues and friends who are starting a company together. Those aren't necessarily bad discussions to have. They may not be necessary, though. We'll address that on the next slide. Next is kind of voting agreements, and the politics of a corporation do not necessarily have to follow the economics of a corporation. I mean, if you divide up ownership 60-40 for whatever reason, or 30-30, 30 and 10, you may not want to have, you still may want decisions to be made collectively. So a voting agreement among the founders. So for certain things, issuing new shares to new people joining the company, selling the company or accepting capital, the default position on a corporation would be, the most number, 51% of the shares wins. But you may decide that, if you're sitting there with each a third, that you may want two partners to have to make the decision. And I use the term partner not in the legal sense, to make a decision to either accept money or to sell the company, rather than just a majority vote. And that actually points out one of the problems. If it's a third, two can vote against one, and that's easy, so you don't have a tie. But what happens if it's 50-50? How you break a tie can be a very interesting issue. That came up in my personal life. My father owned a minor league baseball team, and he was 50-50 partners with his partner. And then they started to disagree, and they never had put in resolution how they were going to resolve their disputes. The pros and cons of voting agreements and buy sells and type things like that. The pros are it forces discussions to ascertain that everybody's in agreement as to kind of how many hours they're going to put in, how much time, what their contribution is, what people are expecting from them going forward, which quite frankly allows you to resolve disputes before they happen. Think of it a little bit, like a prenuptial agreement. If you were to get down into the weeds as to who's taking out the trash twice a week and who does the vacuuming, all of these things, they can be good discussions to have. The downside is there can be lingering resentment when, somebody who felt that they were, an even contributor to all of the technology that was developed discovers that they're not as even as they thought they were anymore. Obviously, there is a cost to writing this all down and having a lawyer draw it up. And of course, you're never going to be able to foresee every single thing that's going to come up. And as I said before, it may not be necessary. And one of the reasons it may not be necessary is if you go and accept outside capital, and this is why I actually don't advise clients to spend a lot of time on these agreements, is that outside capital is going to come in and see this very fancy shareholders agreement with voting and who's doing what. And they're going to say, that's really well and good, and it's great you did that agreement, but we're going to tear it up because here is the way the corporation is going to be governed going forward if you want our money. And unfortunately, you will probably want their money. So, you may not need to open the wounds if you're going to be a venture capital backed company going forward. If you don't think you're going to need money and you're expecting to, be 4 to 5 years with just the initial founders growing the company, then, it's probably worthwhile. Companies seeking venture capital, my advice is, as much as it pains me to not have people spend money on lawyers, is to not spend money on lawyers. Next slide, please, Ria, or actually next 2 slides, we'll get to the employment agreement slide. Employment agreements basically establish a contractual relationship between the company and the employee. And they basically modify what would exist outside the contract. Sets out salaries, duties, severance, and whatever other obligations may be there. They identify and protect corporate assets in terms of making sure that, once a corporation is formed, everything that, is done by an employee of the corporation, intellectual property wise, belongs to the company. And it governs the ownership of old and new intellectual property. Again, it's part of the contribution to the company. If you're a scientist and you're working on 4 different projects, and we've seen this come up, and this is just the commercialization of one of them, we usually make sure to exclude, or the employee insists on excluding their, unrelated research to the startup, because that's not part of what's, that shouldn't belong to the startup. Essentially, in an employment arrangement, a lot of times for senior executives, we refer to them as employment agreements, but they're truly severance agreements. They really just govern what happens and provide protection in a downside. On the next slide, please. Most employees are what is referred to as at-will employees in a company. There's no concept necessarily of tenure. People can be fired at any time for any reason. And so severance and things like that will, provide for what happens if you're fired, a certain number of years or months of pay, what happens to your benefits, what happens to accrued bonuses, the reasons you may or may not get severance for a particular reason. Next thing that kind of governs employment mobility, at least on this slide, obviously kind of non-competes. A non-compete says if you quit or if you're fired, for a given period of time, you can't go work for a competitor of the company that you've been working for. Obviously you wouldn't be able to take any of the intellectual property you assigned to the company, but, there's not a Harry Potter-esque way of taking the knowledge out of your head. So, obviously you walk away with the knowledge. So it's important to keep for the company to keep you from competing. Now, as a general rule, the courts frown upon enforcing non-competes. In California, they are completely unenforceable, except in the context of sale of a company. In the other states, they are gravitating in that direction. Every year brings a new couple cases in a new couple jurisdictions where courts cut back on the ability of companies to enforce that. Obviously, you have, as an employee or founder of a company, you have a duty of loyalty to the company that, you can't, hurt or damage the company in any way. The patents and copyrights obviously would be assigned to the company as part of the joining of this. I think trade secrets comes up later. Tortious interference would be, if you were to take your IP and try to compete or give your intellectual property to a separate company, that could, you could be found for tortious interference. Litigation, most things in an employment agreement are there to protect the company, balance the rights and obligations. And unfortunately, they give the company the ability to, sue a former employee for breaching, failure to assign the intellectual property, theft of intellectual property, competing, whatever it might be, that does that. And so these are kind of the, rash of theories under which, I'm sorry, next slide, Rhea, I skipped ahead on you. On litigation claims that you could be sued for if it doesn't go right. I would say probably the most common of those are non-competes, confidentialities, which obviously in the case of university startups can be an interesting issue if the one of the founders remains as a professor and continues to publish in the area. And then non-solicitation. Non-solicitation just basically means if you leave, you can't take other employees, or if you move ahead and get customers, that you can't take your customers of the company with you. Next slide, please. Okay, we better start speeding up again. Obviously the company needs to identify its intellectual property, which is important in these agreements, so that they can protect it, convince the court it was properly assigned to the company. Next slide. You can basically protect any kind of intellectual property there is, trade secrets, information you desire to keep confidential, proprietary information, which is really just a variation of trade secrets, but maybe something more mundane like business methods or customer lists or financial data about the company. Obviously, patents are public, but obviously people know about patent litigation. We're not going to get into that. Copyright's the same as patents. Next slide, please. Trade secrets, everybody kind of wonders what they are and how they are measured. Basically, obviously, the intellectual property underlying a trade secret has to not be generally known. It has to provide a competitive advantage to the company in question. And then the company needs to take reasonable measures to protect itself and keep it confidential. So again, in the employment agreement, we're very careful about calling out trade secrets as something that we are protecting, and setting up methods for doing that. I think probably the most famous trade secret in all the world is the formula to Coca-Cola. They're reasonable measures to keep it confidential. I think there are only 3 or 4 living people at any time who actually know what the formula is. The formula is written down and locked in a safe within a second safe, and the safes are under guard at all times. So, I've never actually seen the safe where they keep the formula, but I'm told it looks like one of those nuclear bunkers with guards on top of guards. Protecting intellect. Next slide. We talk about the offer letter. Next slide. Usually as part of an employment agreement, it can be done as either part of the employment or separately. There's a proprietary information and invention assignment, and that will specifically call out the intellectual property that's being assigned to the company. We talked about work for hire doctrine. That's basically if you're working for the company, anything you're doing belongs to the company automatically, unless you carve that out at the start of the employment agreement. But as an advisor to companies, I would never suggest that to be done. Shop right doctrine is kind of an English version of the work for hire doctrine. Next slide, please. We talked about non-competes briefly. They generally have to be reasonable in terms of length of time, temporal, what's covered, geographic, in what area. Obviously, companies dealing in the internet and most technology companies are kind of global these days, so geographic becomes a little bit less specific, and scope of activity matters as well. I mean, everybody on this call is likely to be a senior executive at the company, so it matters a little bit less. But you couldn't stop it would be very hard to stop your salesman for your software product from going and becoming a salesman at another company. And so, as you move your way down the officer chain, the agreements become harder to enforce. Next page. An otherwise enforceable agreement, a judge would look at it and say, is it justified that you restrain the person in this way? And you have to pay somebody for a non-compete. Next slide, please. So basically what that means, though, is that you can't 2 years after the person started working for you, come up with a non-compete and not give them some concept of consideration, money or equity to do that. The next slide is non-solicitation of customers and employees. We've kind of talked about that. Next slide, please. Protecting intellectual property during employment. I think you can every company has policies to how they handle, protect, and maintain their data. That's becoming an increasingly important part of companies, especially with hacking and things like that, which lately focuses on customer data, but obviously, intellectual property can be anything on your computer system and service, and your trade secrets, if on the computer, could be hacked if you're not careful. Probably why Coke doesn't keep the formula on the computer. The next slide talks, we discuss a little bit about ways of protecting it. Protecting intellectual property at termination. So the next slide, please. Is you make sure that people know what belongs to the company, what they can and can't do when you terminate them, who they can talk to, what they can do, and such is all kind of an important part. It's part of the HR function. Next slide. Usually gets done with, we always say to document this stuff in writing. So there's always a letter to the informed employee. There may or may not be a letter to a new employer. Sometimes that's a bit over the top and you don't want to get into that. The next slide, we talk about all the various litigation claims again. Next slide is kind of the remedies, what you can get. A company could sue you if you can get money damages. They can get you to stop doing whatever you're doing. You could win and get reformation of the agreement. You could get a declaratory judgment that says, hey, the non-compete is unenforceable because it's too broad, and everybody can fight for who gets attorney's fees. Next slide. Typical case in these things is to seek either a company seeks temporary or permanent injunction for the loss of their intellectual property or their breach of a confidentiality or non-compete agreement. Money damages generally don't put you back where you want to be. They're very fact specific, so it's I can't answer 20 questions in the question and answer session about, well, if I do this and that, what would happen, because the answer is I need a lot more information to do it, which is why in the last we always say set this out consistently with an appropriate document. And obviously we ran through this very quickly, but it is very important. It is your way of protecting your intellectual property. And this is also very important to investors because they're going to want to see that you have the appropriate protections. Next slide, and then the next one after that. So we'll get into stock option plans, which my experience is people care a lot about, and I think we're good on time for some questions coming soon. Basically, a stock option plan is company grants an employee or a consultant the right to purchase a specific number of shares at a preset price, which has to generally be the market value on the day of grant, or else there are tax consequences. If it's not, we're going to ignore those tax consequences and assume that you're doing it at fair market value on the day of the grant. I know this will come up in the question, so I'll address it now. The board of directors generally has to determine what the fair market value is. If you're a public company, it's easy. It's whatever the stock is trading at on the day of the grant. If you're a private company, the board has more latitude as to what the price is. There are rules about it. They are getting progressively stricter on it. And we can answer specific questions in the question and answer. There are tax requirements to set up a plan, and there are accounting issues with a stock option plan. Next slide. The board approval. And obviously, the board just has to say, hey, we're going to set aside, 1 million shares for our stock option plan. The stockholders have to approve the plan as a corporate matter and as a tax matter. If the shareholders don't approve the plan in the first year, the grant of an option would be a taxable event to an employee. It is not normally a taxable event if the stockholders approve the plan within 1 year of its date of adoption for the board. And as I said, the board sets aside shares. The amount that's set aside, varies. There are ways to calculate it. It's kind of fact specific to the company and how long how long you expect to set the shares aside for and such, is what really governs things. Next slide, please. Make sure I'm still in the same place. Yep. The grants are done by the board. If it's a small company or if it's a larger company, it's a compensation committee, a delegation portion of the board. Generally, in all my companies, the CEO and the senior management team make the recommendations to the board, and the board just approves them. Vesting, you don't want to give people options that are not subject to vesting. What vesting basically means is if the employee doesn't stay long enough or hit whatever benchmarks you may put on them, the shares come back to the company. What you always are trying to prevent is what is colloquially referred to as a hole in the cap table. For instance, you bring on a chief scientist who you decide is, and that role is normally holds 10% of the company. That may not be the right number. I'm just using it. You bring that person on, and if they walk out 3 months later, you've given that person 10% of the company for doing nothing. And so all options, or almost all options, are subject to some concept of vesting. Nearly all are time-based. The only ones that tend not to be, quite frankly, are salespeople. But almost everybody is time-based. The typical is no vesting in the first year. Then a quarter of the options will vest after the first year. And then the balance will vest over the next 3 years. And the question is, do you do it annually, quarterly, or monthly? And their practice is extremely mixed. Employees obviously prefer monthly. Companies prefer quarterly or annually. Restricted stock versus options. Under an option plan, you can, if you do set the plan up properly, you can either give a stock option to somebody or a share of stock to somebody. And the share of stock would be subject to vesting as well. Stock is a little bit more complicated. Even under an option plan, giving somebody a share of stock is a taxable event, and they have income tax due on the day that whatever restrictions or forfeiture restrictions go away. So if you put restrictions on, give somebody 100 shares of stock and the restrictions go away over 4 years, as the restrictions lapse is when the tax is due. So by that 4th year, the tax bill could be quite high if the company is going well. As a general rule, only very senior executives get restricted stock, and that's largely because of the tax bill that's associated with the stock. Most run-of-the-mill employees don't have the money to reach into their pocket to pay the tax on the stock at that point. Lastly, I put this in the slide deck after the last time because everybody said, well, what's the difference between an option and a warrant? And from a corporate finance point of view, there is absolutely no difference between an option and a warrant. They are both the right to buy a share of stock at a specific period, at a specified price, at some point in the future. The difference is an option is only issued under a qualified option plan, and a warrant is any contract between a company and a third party to provide that right. Next slide. Obviously, the pros of stock option plans: it rewards employees for contributing to the equity value of the company. It aligns the employees and owners together. The employees feel as if they have a stake in the company, and perhaps more importantly, it conserves cash. People will perhaps take a lower salary in return for an option grant, and that they feel that they have upside. Next slide, please. The cons of the stock option plans: it's dilutive to ownership, obviously. So you're giving shares to people, and that dilutes the current owners. The fairness of the administration: Joe got 20,000 options. Why did Jane only get 15,000 options? New accounting rules make it more difficult and complex. The new tax rules reference to this does not reference the current tax bill. I have absolutely no idea what the current tax bill is going to do about options. They're being batted about in conference committee as we speak. But I can assure you that it probably will still be true that the new tax rules will make administration more complex, because simplifying does not seem to be on the congressional agenda. The fourth point is kind of an esoteric one. Option value is now an expense from an accounting point of view. It can be difficult to administer. Then in a public company or a private company, if the valuation falls, the options lose meaning to the employees, and so their retention value as a retention tool doesn't work as well. And then last slide, I think, is just questions. So Rhea, do we want to open it up to questions?
Okay, our first question. If the IP was developed in the university, who handles the IP issues? Is it the responsibility of the inventor? Go ahead, Andy.
It would be the responsibility of the inventor to, know and understand what the university's policy is on, intellectual property developed while you're at the university. And then most, if not all, universities now have a commercialization or a technology licensing / transfer agreement that will work with the inventor to get the intellectual property out of the lab and into the market. Some universities take a piece of the equity, some take a licensing fee, some want a reversion. Some universities are very, very good at this. Some universities are still feeling their way out. Obviously, the larger research universities have a well-worn path as to how they do this. Surprisingly to me, after MIT and Stanford, and I haven't seen the statistics in a couple of years, the university that's always third and the most startups created is actually Utah, which kind of shocks everybody. But yes, ultimately, it's first the responsibility of the inventor, and then working with the startup office or commercialization office to figure out how to create a viable entity. Next slide.
Okay, regarding personnel who leave the university, should policy prohibit inventors to copy their laboratory samples, notebooks, and other research data and take the copies with them?
I think this is part of what gets negotiated out, is that, it is not just the, intellectual property, the patent that goes generally. It's, it's almost, obviously the research data people may not recall, but the methodology, the way things were invented and the analysis, you can't really leave that behind. And, since it's in the university's interest to have the startup function and generate, return, get a product that can be commercialized so that they derive a licensing fee, or if they're taking a portion of the equity in the startup so that their equity value becomes worthwhile, it's in the university's interest to make sure that the inventor has whatever the inventor needs to move the intellectual property forward. So, I think, whatever policies govern the professor or the inventor while he's at the university, if they would go to university A to B, would apply. But when the inventor is leaving and taking intellectual property with him as part of a startup and is to some extent entering into a partnership with the university, this generally gets worked out as part of that. generally see it go with the startup.
Okay.
Next.
I'm a grad student doing research at a major university. Can I use my research that I promote at the university to create a company?
That's one of those good questions, and the answer is a stunning that depends on what your employment, if you're merely a grad student, the question really covers, if you're a grad assistant in teaching, you probably have some employment arrangement or agreement with the university, or there may be a policy governing it, and you should make sure that you know what that policy is before you go and take things that you've developed and do that. Now, if you're just moonlighting in the lab and have created something and the university has no claim on it, the answer is yes, you could promote it, use it to create a company without going to the university. But I don't want to give you that advice without knowing more specifically, what you're doing. So that's a question that you shouldn't get a 30-second answer from a lawyer on a webinar from. You should make sure you look at whatever arrangements and agreements you have with the university on use of their facilities and such, because there may be work for hire and if not work for hire, shop doctrine, that you're using all their stuff so that everything you may do may belong to them. Or you may find a situation where your research is funded by the federal government and you may not, or federal government or a commercial backer, and you may not know it, and they may in fact own the intellectual property and you're not aware, you may not be aware of it. So my advice is to check carefully before you whimsically go off and start a company with something that may belong to your university or the funder of the research that you're doing. So like I said, don't take this as a 30-second response. So don't bet your life on it.
I'll just add a bit to that. We see student-led startups at NSET too, and I think Andy's advice is great advice. I just want to say that, again, universities are generally interested in promoting these startups and helping them to succeed. So let's go to the next slide. Next question. How often and under what situations do founders have or not have employment agreements?
Okay, I mean, generally speaking, founders, when it's just if it's just you and you're the 100% owner of the company, you don't need an employment agreement. If there becomes, if there's 2 or 3 of you founding the company, we start to think about employment agreements, if only from a severance point of view, so that if you leave or the other 2 decide they don't like you anymore and they push you out the door, that those things are covered. I would say probably about 20-ish% of startups at that point will create employment agreements. It's as much a cost issue as a likelihood issue. I would say, the more founders there are, the more likely you are to have an employment arrangement or an employment agreement. When you will absolutely have one is when money comes in the door. The money will want to document the ways in which you're working, and you will want it because the prospect then of being pushed out or pushed around, not being the chief executive officer and becoming the chief scientist becomes real. And that's when it becomes more important to set forth those rights. So I would say at the start, if it's just one person, no. As you get multiple founders, the more founders there are, the more likelihood there are, but it's still probably 20-ish, 25%. But when money comes in, it becomes 100%.
Okay, thank you. Next question.
Wow, congratulations. Faculty, I think everybody can see these, right? My faculty advisor would like me to work with him on his startup. What questions should I discuss with him? One is, precisely what you're going to be doing. obviously, but then the questions around from a business point of view, is what can he, what will the professor, what does he want to pay you for, your work? I guess to some extent how it fits with your grad studies program, but then more importantly, and this is something, I know we talked about this a bit the last time in terms of equity and startups, is, what percentage of the company will you be getting for doing this work for them? Money, equity, and, how it fits with the university would be the three, major things to consider and figure out and work out. And then, if there's equity involved, put it in writing, even if it's an email back and forth that I'm getting, you're agreeing that I get 20% of the company as a co-founder of the company, and you get a reply email. Ideally, you document that with a lawyer, but at the very least, get a, confirmation email back on that, so there's at least some concept of a writing. But it would be money, equity, and, how it affects your studies at the university.
Thanks. Next one. What are founder stocks? Are they immune to dilution with subsequent rounds of funding? Can they be made immune?
Founder stock is literally just a term that means for the first people in. There's some special tax code provisions that, the founders of a company basically get their stock, and it's deemed to be worthless for purposes of tax purposes. They are not immune to dilution. No stock can be is immune to dilution with subsequent rounds of financing. They can be made immune. The problem is that becomes extremely expensive from a tax point of view to the founder, and would generally render the company completely and totally unfinanceable. Because an investor isn't going to want to constantly have a founder at 50% if they put in, if the company's worth 10 million and they put in a $10 million check, and so they think they should own 50%. If the founder comes back and says, well, no, I get 60% no matter what, because that's what I own now, and my other co-founders have the 40. Nobody's going to give you the money to invest in your company. Now, to keep you at 60%, the ways to do it would be either to grant you options so that you could be buying shares that would let you go back at 60%. But again, those shares would be at fair market value, or to give you new shares to keep you at 60%. But as you recall, I said every time there's a grant of shares, that's a taxable event and the fair market value. So in our little example there of 10 million and 10 million and wanting to keep the founder at 60%, that's a 10% on 20 million to get that's $2 million of value, and that would show as $2 million of income to our hypothetical founder. And I'll leave it to the Congress to tell me what the tax rate on that would be next year. But you'd have a current tax bill on $2 million of value. So they are, founders just means first money in. They are not immune. No stock is immune to dilution with subsequent rounds of financing. And the way it gets made immune is generally through additional option grants, because what will happen is that the investors will want to make sure that their CEO is still at a, hypothetical 10% equity position in the company. And if the CEO is gone below, 10%, they generally will grant options to bring the CEO back to 10% so that they have enough skin in the game from the investor's point of view. Next slide.
Glenn, Andy, I think we have time for one more question.
Okay.
As a founder, how much equity should I expect when talking with my university?
Well, I think, the answer is start with 100. A lot of universities actually don't want to own the company. They only want a small percentage, or will take, would prefer to get cash for licensing fee because they don't know what to do with the equity. So as a general rule, you should assume you will be getting 100%, and the university will be taking a relatively small percent away from you on that 100. But that, my experience has been, it's never a situation where the university owns 90% and the founder owns 10. It's usually, it's almost always the other way, and that 10 is sometimes much smaller. I mean, I've got 2 university clients now, university startup clients now. One of them the university owns, and neither has raised money. One of them the university owns nothing. They just have a license fee on the IP, a license fee based on gross revenue. And then the other, the university has a 2% plus a license, a smaller license amount, but a 2% equity stake in the company. And then, Glenn, I don't know, what have you seen? Is your experience different?
In terms of equity?
Yeah.
No, not really. No, I think that would be right.
Yes, I mean, I think you'll find that you'll end up much like, much as if you develop this on your own in the basement of your house, you'll end up with a similar equity percentage, or than you would by having been at the university. And if that's, I guess, all we have time for, Ria, I just want to thank NCET 2 and Glenn and Ria and Tony Stanko for allowing me to be here, and wish everybody on the call a happy holidays and a happy new year.
Thank you very much, Andy, for your time and for spending, this hour with us to talk about this really important topic. And Glenn, thank you as well for moderating the Q&A session. So to our audience, if you'd like to follow up with us to engage with NCET 2 and the STOs, we've had some questions about, how the STOs can help them if they're putting together a startup, if they have IP. So all you need to do is you can send us an email at startupdevelopment@ncet2.org, and we can answer some of your questions, or you can go directly to our website where there is more information on what the startup development program is. So you can also become an STO if you're an ex-corporate or a serial entrepreneur or an active angel investor, and we'll work with you as well to see if this program is right for you. So as Andy said, thank you everyone for joining us. Have a good afternoon, and, Merry Christmas and a Happy New Year. Thank you. Bye-bye.
Bye.
Bye-bye.